Hello, everyone, and welcome back to another episode of Courtroom Confidential, a weekly series covering headline-making criminal cases from across the country. I'm your host, Joshua Ritter, a former Los Angeles district attorney and now a criminal defense attorney, bringing you what I hope are unique insights from both sides of the courtroom. Let's jump right in. First, lawyers for Chad Doerman, an Ohio man accused of shooting his 3 children execution style, have asked Claremont County Judge Richard Ferentz to throw out statements made by Doerman after his arrest, saying his Miranda rights were not read in full and that detectives questioned him for hours without a lawyer present. Claremont County investigators said Doerman originally confessed to the murder soon after his arrest, saying he planned the killing. Get this, lining up his 3 sons, ages 3, 4, and 7, and executing them each with a rifle. Prosecutors even said that one of the boys tried to run away into an open field before Doerman chased him down, dragged him back to the house, and killed him. This is even just difficult to talk about, to just explain to you folks what this man did. The boy's mother was present during the scene and sustained a gunshot wound to the hand. Despite his confession, he later pled not guilty to the charges. Doerman faces 9 counts of aggravated murder, 8 counts of kidnapping, and 4 counts of felonious assault. All right, what's going on here? This is dealing with Miranda, and Miranda is always dealing with what we call custodial interrogation. What does that mean? Well, the first part is custodial, custody. Essentially, are you in custody? Are you in a situation with the police where you are not free to go? This doesn't mean that the police have stopped to speak with you freely. This means where you're in a station in the back of a squad car in handcuffs and you are not free to go. And interrogation. That's another important part. Are they actually actively asking you questions, or is this information that you're simply giving freely? It's also about, are the questions and answers being asked of that suspect, are they statements that will be admissible in court? The suspect must be advised of their rights beforehand if they intend to use those statements in court. And I get this question all the time from people who've been arrested. They said, I never got advised of my rights. And they feel that somehow that makes the arrest illegal. It doesn't. This is something that we've seen from TV shows. You know, every officer reads them their rights as they're arresting them, as if that somehow makes the arrest legal. It really just has to do about statements being made. And it only has to do about those statements being admissible in court. They can ask you a bunch of stuff without advising you of your rights, and you can give a whole full-fledged confession. But what they need to do is advise you of those rights and then ask you questions if they want that to be admissible in court. And you will, in fact, see officers use this tactic. They will speak to a suspect freely, not advising that person of their rights. Then stop the interrogation and go, okay, I need to advise you of certain things. You realize that you have the right to remain silent, that you have the right that anything you say may be used in a court of law, that you have a right to an attorney. And they go on and explain everything to them, getting all of their full advisement of the rights and acknowledgement that they've heard their rights. And then they go, okay, now tell me what you were talking about earlier. And the guy gives that full-fledged confession again. Is there anything illegal about that? The current landscape of the law says absolutely not. And there's a string of cases surrounding this ever since Miranda, talking about all the different aspects. However, while on the stand Wednesday, Detective Michael Ross, who led the investigation, said he read Doerman his Miranda rights verbally, though he admitted he did not read those rights in full. He said he was holding a card listing the Miranda rights at the time, but said, quote, "I'm not a robot," Ross said. "I probably should have read the entire card, but I'm not a robot." What is that going to come down to? It's going to come down to of whether or not the rights were sufficiently advised to him. This isn't some sort of script that has to be read. What the officers read off of a card is what they know has been accepted by case law to be proper. But if they deviate from that in some sort of way, it doesn't declare the whole thing immediately insufficient. It's just whether or not a court is going to review that and decide what was actually read, what was advised. Is that enough to have put them on admonishment of their rights? They just have to be made aware of the rights that they're had. According to the motion filed by Doerman's defense attorney, Doerman asked for a lawyer early on in the investigation, but was not given the opportunity to speak to one. All right, this is another issue at play here. Your Miranda rights are as follows: that you have the right to remain silent, that you have the right to anything that the suspect says can and may be used against them in a court of law, that they have the right to have an attorney present before and during questioning. And if the suspect requests an attorney, all questioning must stop. But the question becomes, how long does that last? If a person says, I'd like to speak to a lawyer, the officer should stop. The investigator should stop all questioning. But if that suspect later on says, hey, I want to talk to somebody, and he starts talking to the detectives freely and of his own volition, that's seen as a waiver of those rights. He may have asked for an attorney, but now he's re-engaging with the officers, and this oftentimes becomes an issue because it's amazing how many times these guys in custody want to talk. They want to explain themselves. They think that if they can only talk to someone, they would be able to reason with them and get themselves out of this mess. According to Detective Ross, the individuals Doerman mentioned as being his family lawyers, one was his dad and the other was his aunt, who are not trained lawyers. So did he really request lawyers? Ross said that neither name that he gave me were even close to lawyers. So he's saying, I want to speak to my lawyers. Well, who are your lawyers? My dad and my aunt. Well, those aren't lawyers. Is he really requesting a lawyer at this point? Ross went on to say that he just keeps talking about something unrelated to the lawyer issue that I was trying to clarify. So it sounds like he started to re-engage the officer even after he requested a lawyer, talking about something independently. Here's my thoughts on this. This case is disturbing beyond imagination. And I think this is all noise. You have to remember that even if parts of his admission are kept out, it sounds like he admitted to it early on of his own accord before officers even began to question him. But even if all of that is all kept out, remember the circumstances surrounding this murder. There's an eyewitness, the mother, who was shot in the hand during all of this. There's 3 dead babies. This case is going to go to trial and they're going to convict this man. And all of this is just noise ahead of time. Not trying to say that it's lawyers pulling fancy tricks. They should defend their client. And these look like ripe avenues for them to make argument. But end of the day, this man is going to go down, and he absolutely should, for these types of heinous, unimaginable types of crimes. We will continue to update you all as this case develops. But moving on, we move to a jury in Anchorage, Alaska, deliberated for less than 3 hours before finding Brian Stephen Smith, a South African man, guilty of killing 2 Alaskan Native women and video recording one of the brutal murders. Smith was convicted on 14 charges, including murder, sexual assault, tampering with physical evidence, and misconduct involving a corpse for the murders of Veronica Abuchuk and Kathleen Henry. Both victims had experienced homelessness and were from small villages in western Alaska. Prosecutor Heather Nobriga delivered the state's closing argument on Thursday morning, focusing on disturbing videos and photos that had been shown to the jury, but not released to the public. They allegedly these videos, Smith torturing and sexually assaulting the murder victims as they were dying. Nobriga walked the jury through the state's evidence, which centered around the disturbing videos and images. Apparently, even during some of these videos, he is mocking the victims and telling them how they're going to die. In addition to the video of the murders, the jury also watched a 5.5-hour police interrogation of Smith, during which he told officers, quote, "I'm convinced I have done this. I know I must have done this," adding, "This is me. That is my stomach. That is definitely me," when shown clips of the murder, while vehemently denying any memory of the murders. Smith told police during the interview, "This is not my fault. I've dug my own grave. I cannot blame anyone else." I don't think it's a shock to anyone that this man was convicted. Many people wonder, in a case like this, why is he even fighting it? How could he possibly plead not guilty? So what's going on here? Many Many cases, I think it's important to understand, go to trial where there is overwhelming evidence of guilt. That is not uncommon at all. It's a misconception to think that the only things that end up at trial are cases where no one knows what happens and we need a jury to tell us what happens. Oftentimes, there's overwhelming guilt. Now, that's not to say it's always true. Many times things go to trial where there is problems with proof and there is an innocent person and it does need to be decided by a jury. But especially when the defendant is looking at life in prison and in particular the death penalty, prosecutors take these cases to trial knowing they're going to go to trial and they refer to them as a long plea. Essentially, we're going to put on the evidence, protect this person's rights, make sure a judge makes all the right rulings, and then this person will be convicted, and that will be a solid conviction. And it's not a waste of time. Our criminal justice system isn't only about finding defendants guilty, but it's also about holding law enforcement accountable to a certain standard, and that's what the trial system does. Oftentimes, that is the best mechanism to simply test all of that out. So sentencing is scheduled for this case for a 2-day hearing to be held on January 12th and 19th later this year. Finally, James Crumbley, the father of Oxford High School shooter Ethan Crumbley, was in court on Wednesday for a hearing that revolved around which witnesses will testify in his manslaughter trial. Like his recently convicted wife, Jennifer, James is facing 4 charges of involuntary manslaughter in connection with his son's mass shooting that left 4 students dead. Hannah St. Julian, Madison Baldwin, Justin Schilling, and Tate Mayer. 6 other students were injured in the shooting, along with a teacher. Similar to his wife, James is also accused of making a gun accessible to his son and failing to get him proper mental health care. In court, the defense argued against the prosecution's intent to call 2 former students to the stand. The students, both now over the age of 18, survived the gunshot wounds inflicted upon them by James's then 15-year-old son, Ethan. James's defense attorney, Merrill Lehman, argued, while I can't imagine what those 2 students went through on November 30th, 2021, their testimony is not relevant in the trial against James Crumbley. How could this be true? How could that not be relevant? Well, what's going on here? The attorney goes on to explain. He's been charged with 4 counts of involuntary manslaughter, and this is important. He's not charged with assaulting anyone with a firearm. He's not charged with shooting anyone and wounding anyone. He's charged with 4 counts of involuntary manslaughter for the actions of his son. Now, the assistant prosecutor on the case, Mark Keast, said the 2 students would provide testimony different from that of a teacher who was also shot and the assistant principal who saw James' son walking down the hallway with the gun in his hand. The prosecutor went on to say, when we have actual eyewitness testimony available, it is important for the jury to hear that perspective. This all comes down to a question of what we call prejudicial versus probative evidence. That is a question that's constantly posed to the judge in making decisions on what evidence will or will not come in. First of all, the evidence has to be probative, meaning, does it add value? Does it move the needle? Is it advancing the case? You can't just bring evidence in because you feel that it makes the defendant look bad. It has to be somehow related to the charges and moving the jury towards a conclusion of guilt or not. But then beyond that, there's also the question of, is it prejudicial? Now, almost all evidence presented against a defendant is prejudicial to some extent. It's going to influence the jury. That's part of the reason for it. But the judge has to do a balancing act here. He has to weigh the evidence. Is it more prejudicial than probative? Meaning, maybe there's probative value to this. Maybe there's worth to it. But is it going to so inflame the jury that they may convict this person for reasons beyond the actual evidence and facts established in the case? And that's really the question being presented here. And I'm sorry to say, it may not be popular, but I think the defense has a real argument. I think this is a problem. I think if they start bringing in too much evidence of the actual shootings, that may inflame the jury. There may be a real argument to say that the jury is convicting this person because of how horrible the crime is committed by the son not the crime committed by the father. That's a problem. Do I want people held accountable for these types of crimes? Absolutely. Do I want those convictions to stick? Absolutely. And that's why it's important that whatever the prosecution does, you understand they wear several hats. And one of those hats is to make sure that the conviction that they're getting isn't just at all cost, that the conviction that they are securing is one that will last. You start bringing in too much evidence, you start being a little too cute by half, and you may run into problems down the line. And that is what my fear is here. The hearing on this motion is scheduled for February 28th. Jury selection is set to begin on March 5th. So that's coming up and we will be following it. Also making headlines this week, both Chad Daybell and Lori Vallow Daybell are back in the news. The doomsday couple, Chad and Lori Daybell, were both in court this week for separate hearings. Chad Daybell's attorney, John Pryor, withdrew his request to postpone Daybell's murder trial in Idaho. And as of Thursday's pretrial conference, the trial is set to start on April 1st. Meanwhile, Lori Vallow Daybell, who's already serving 3 life sentences for convictions in Idaho, could be seen smiling and chatting with her attorney during her scheduling conference in her Arizona case. Attorney said that they would be, quote, going through discovery for the next foreseeable months. Vallow Daybell is facing charges of conspiracy to commit first-degree murder in 2 separate indictments in Arizona. The body of 11-year-old Audrey Cunningham was found in a river on Tuesday after being reported missing from a small Texas town for 5 days. Jail records revealed Wednesday that 42-year-old Don Stephen McDougal, who was also supposed to be dropping Audrey off at the school bus that morning she disappeared, has been charged with capital murder. On the docket for next week, Rebecca Grossman here in Los Angeles. Jury deliberations began this week for Rebecca Grossman in Los Angeles. Prosecutors allege that Grossman was impaired by alcohol and Valium as she recklessly sped her Mercedes through a residential neighborhood, chasing her ex-Dodger boyfriend before killing 2 boys in a crosswalk. If convicted, 60-year-old socialite is looking at 34 years to life in prison. Also, Hannah Gutierrez-Rees. Trial continues as day 1 of testimony was Thursday. Trial is expected to be 2 weeks long with testimony from actors, directors, gun handlers, and ammunition suppliers. This is, as we all know, the armorer in the now infamous Rust on-set shooting case. Finally, Michelle Troconis case in Connecticut. The defense began to present its witnesses Wednesday. Testimony in that trial is supposed to finish by Friday or Monday, and we will, of course, be bringing you all of the updates and our thoughts. Once again, I am your host, Joshua Ritter. You can find me on all social media platforms at Joshua Ritter ESQ, or please go to my website, joshuaritter.com. Thank you again for joining me. If you enjoyed this episode, please like, subscribe, share your thoughts on these cases in the comments, and feel free to suggest cases that you would like me to cover. Have a great weekend. I'll see you next week. And thank you again for joining us at another episode of Courtroom Confidential.